Now new tonight, a Louisiana inmate is asking the nation's highest court to give him the right to a new trial after a non-unanimous jury convicted him. Dedrick Edwards is serving life without parole for armed robbery, rape, and kidnapping. The only black member of the jury in that case found Edwards not guilty. The U.S. Supreme Court has already ruled that the Sixth Amendment establishes the right to a unanimous jury in federal and state courts. The justices heard arguments today about whether inmates whose convictions became final before that decision can now take advantage of it.
To handle that?
It might be that the unanimity rule allows more guilty people to go free than it stops innocent people from being convicted. Or at least it's just not certain.
Now, Edwards is one of about 1,500 Louisiana inmates still in prison after a non-unanimous jury verdict.
Well, that Supreme Court case is sparking plenty of reactions here in Louisiana. I caught up with some of them. Whether you side with one argument,
Louisiana's non-unanimous jury scheme was thoroughly racist and discriminatory in its origin,
or the other.
A supermajority verdict does not render a trial fundamentally unfair, nor does it seriously undermine factual accuracy of the verdict.
The Supreme Court's impending decision on whether to throw out past convictions by split juries will affect Louisiana more than any other state, and that's no coincidence.
We should accept these cases being retried or whatever process they have to go through.
Jerome Morgan spent a chunk of his life at Angola after a split jury convicted him of something a judge later ruled he didn't do.
I spent 20 years there fighting for my innocence and also just growing up.
Now he says the justice system must grow up and reconsider cases of some 1,500 Louisiana inmates still serving time after non-unanimous verdicts.
That's our responsibility as a society, as a government, and as a court system.
But even some who support Louisiana's 2018 move requiring unanimous juries for future verdicts say applying it retroactively would flood the courts with attempted appeals and plenty of questions.
Surely we have so many people from earlier cases back in the 80s, 70s, people are dead, no longer around. Things are destroyed, cases are gone, witnesses' memories are gone. It'd be extremely difficult to do.
Requiring new trials in long final criminal cases would be impossible in some and particularly unfair to the victims of these crimes.
Though criminal justice reform advocates maintain that's a lower risk than what others may think, and one they'll just have to take.
Judicial expediency and the cost of a new trial really has to be weighed with whether or not people are languishing in prison on a wrongful conviction.
This is up to the Supreme Court to decide. Very bright people on all sides of these arguments in the Supreme Court.
Whatever the justices decide here could mark one of the Supreme Court's first major rulings since President Trump named Amy Coney Barrett to the bench, a Louisiana native among the deciders of this Louisiana case. And while that hearing wrapped up today, the Supreme Court could still take a few months to reach its decision.